We are now live. I think you are still muted.
My apologies. Good morning, ladies and gentlemen. Welcome to the courtroom this morning. My name is Raul Pangalangan. I'm a presiding judge, and I would like to introduce my colleagues on the bench this morning: Judge Solomy Bossa, Judge Ivana Hrdlickova, Judge Adel Maged, and Judge Bertram Schmitt. May I ask the bench clerk to call the case, please?
The ICC is now in session. I will now call the case, Situation in the Fire Republic, in the case of the prosecutor versus Lord Blaze.
Thank you. Thank you so much, bench clerk. I call for the appearances from the parties, please.
Good morning, Mr. President, Your Honors, and may it please the court. My name is Moramai Coleman, and I'll be representing the prosecution in the case against Lord Blaze. I'll be speaking for the first 13 minutes, and my co-counsel, Ms. Anna Wischerman, will be speaking for the remaining 12. We reserve 5 minutes for the rebuttal. Thank you very much.
Thank you so much to the prosecution, and for the defense, please.
May it please the court, my name is Basanti Mardemutu, and I will be acting on behalf of the defense in this matter. I will be reserving the entire 25-minute slot.
Thank you so much. Let us now. The court will now hear from the first speaker of the prosecution, please. Proceed.
Good morning again, Mr. President, Your Honors, and may it please the court. The prosecution submits 4 claims. I will first argue that the case falls within the jurisdiction of the court and that the case is admissible. My colleague will then continue on assessing the interests of justice and the individual criminal responsibility of Lord Blaze for the enslavement of at least 30,000 Earthbowers. In relation to the first claim, it is clear that both the territorial and temporal jurisdiction have been met. We will therefore focus on the subject matter jurisdiction. Within this, we will assess both the contextual elements and the material elements. Turning to the contextual elements, for conduct to constitute a crime against humanity, there needs to be a widespread or systematic attack directed against a civilian population pursuant to a state or organizational policy. There is a systematic attack when the attack is planned or organized or occurs in a regular pattern, as was stated in the ongoing trial judgment, paragraph 2682. Furthermore, there's a state policy when the attack is planned, organized, or directed, as was stated in the Bemba confirmation of charges, paragraph 81. Your Honors, the Earthbound population have been subject to 4 years of oppression by the Fire Republic government. This started in 2015, where all Earthbound rituals and ceremonies were prohibited. It only escalated from there in 2018, where all Earthbound public gatherings were violently disbanded. Ultimately, Lord Blaze enacted the Anti-Extremism Executive Order, which ordered the monitoring of the situation in Blackbound and stopping all apparent threats in the name of national security. This led to the opening of 40 detention centers throughout the Fire Republic, among which Center Rig was the biggest center. Your Honors, entire Earthbound families were sent to these detention centers where they were forced to work on building and repairing cars. It is clear that a systematic attack specifically targeting the Earthbound population took place in the Fire Republic. Turning.
Counsel, if I interrupt, counsel, you are alleging many human rights violations, counsel. don't you think these are legitimate measures of for national security on the part of the state, that it is entitled to take these measures because there is an ongoing threat to its national security, and these are actually human rights violations they can be human rights violations in themselves, but you are alleging that a crime has been committed. Can you explain that to the court, please?
Your Honor, I would answer your question in two parts. First, we do not believe that there's a national threat to security, as the ANG started out as peaceful demonstrators, as can be seen in case facts, paragraph number 4. And only after the Fire Republic itself initiated the violence did they respond to this. And therefore, they did not pose a threat to national security. And Your Honor, could you please repeat the second part of your question? I'm sorry, Your Honor, I think you're muted still.
My apologies. No, precisely the point that even if they're human rights violations, you have to show that they are crimes under the Rome Statute.
Yes, Your Honor. For us to prove the attack, we need to state that there are multiple commissions of acts which fall under Article 7.1 of the Rome Statute. In this case, we have the persecution of the Earthbound population, the imprisonment of these people, and also the enslavement that took place in this case.
Thank you. Please proceed.
Turning to the second argument, the conduct clearly constitutes the crime against humanity of enslavement pursuant to Article 7.1c of the statute. The detainees were subject to various forms of coercion and oppression even before they were held within this detention center. This only intensified once they were sent to Rig. The fact of detention itself clearly shows the presence of coercion in this case. The detainees experienced the control of physical environment, which is an indication of enslavement, as stated in the on-grand trial judgment, paragraph 2712. The detainees were sent to detention centers without a trial or a conviction. They were not told the reason of their detention, nor its length. Their passports were confiscated upon arrival and not returned to them upon their release. Furthermore, the detention center is a heavily guarded island fortress surrounded by security walls and surveillance, as can be seen in case facts, paragraph number 14. Your Honors, not only were the earthbound detainees subject to detention, but within this detention center, they were also subject to forced labor. Forced labor, or the threat of use of force, can constitute enslavement, as stated in the Elements of Crimes, Article 7.1c and footnote 11. Forced labor is all work or service which is exacted from any person under the menace of penalty and which said individual has not offered himself voluntarily. This was stated on Article 2 of the Convention of Forced Labor. Your Honor, the work performed by the detainees was involuntary. They did not consent to work. And even if they did consent, this consent was rendered irrelevant. Consent is rendered irrelevant in the case of detention, where there's a threat or use of force or other forms of coercion, as was stated in the Cunard trial judgment, paragraph 542. Obtaining consent from the detainees became impossible. The environment was so coercive as to negate this. Generally, they were prohibited from exercising the rituals and speaking their own language within the detention center. And more specifically, they lived in a constant fear of punishment. They had to work every day of the week with barely any breaks, and this was done under the menace of penalty. If they refused to work or were unable to work, they would be cruelly punished. They would be separated from the group, put outside in freezing temperatures all day, where they were deprived of food and water. Your Honors, the deprivation of liberty, the control of physical environment, and the forced labor together reached the threshold of enslavement. Therefore, it is clear that the crime against humanity of enslavement took place within Center-Rig. I will now turn to our second claim on admissibility. Within this, the prosecution submits 3 arguments. First, the case has not been tried by another court.
Presiding Judge, may I ask counsel a few questions?
Please proceed, Judge Maged.
Thank you. Do you have Article 7, Paragraph 2C in front of you, please? Okay. Enslavement is a chapter which constitutes certain forms of prohibited acts, such as slavery, servitude, forced labor, and the trafficking in human beings, in particular, women and children. You have to prove that certain form that I have already mentioned have been committed. And you have to provide us with the evidence that this form or this crime was committed. Here we are focusing on the crime on forced labor. Is that right?
Yes, Your Honor, that is correct.
Now we are here in the final stage of you have been in the pre-trial procedures, now we are in the final stage. We need to hear evidence. You only give us facts and law, but I need the link between the facts and the law. The evidence, give me evidence that the crime of forced labor committed. And just for your knowledge, forced labor could only fall with the domestic jurisdiction as an ordinary crime. So what's make forced labor here a crime against humanity, an international crime? It could be an organized crime, like if you have referred to the protocol in combating human trafficking, supplementary to the Convention on Organized Crime, it is an ordinary crime, organized crime. It is not a poor international crime. So I want you to explain on this and give me some evidence that this crime was committed with the elements of an international crime. Please go ahead.
Thank you, Your Honor. Your Honor, in accordance with footnote 11 of the Elements of Crimes, forced labor in some circumstances can constitute enslavement. And the evidence in this case is we have a statement by Haru Rock, which points out the conditions of the prison and the penalty they received when they were unable or unwilling to work, as can be seen in case facts, paragraph number 12. Furthermore, we also have statements by family members of the detained earthbowers, as can be seen in case facts, paragraph number 13, which point out to the confiscation of passports and the being told of the reason of detention. Furthermore, we also have Exhibit 2, which states that materials were sent to these detention centers, such as steel, rubber, glass, and engines, which were used in the forced work of building and repairing cars. And finally, we have the mere fact of the detainment of at least 40,000 peaceful protesters, as can be seen in case facts, paragraph number 10, Your Honor. And finally, we have the aerial footage, as can be seen in case facts paragraph number 14, which shows the environment of the prison.
What I am interested about is the testimonies of the witnesses. Do we have a concrete testimonies of witnesses collected by prosecution, by your office, for example?
Yes, Your Honor, we have the statement of Haru Rock in paragraph 12, and here he describes the conditions of the prison and that entire families were sent to the detention centers. And this was an interview done by an NGO, namely the JHR.
I am done with it. Thank you.
I will now turn to our second claim of admissibility.
Sorry, may I jump in?
Yes, please proceed, Judge.
Yes, I had counsel mentioning the exhibits, and my question is, do the exhibits concretely point to the fact that these materials were being used for the purpose that you alleged they were used for?
No, Your Honor, this exhibit does not concretely state that, but together with the statement of Harurak, we submit that this is what the materials were used for. I will now turn to the second claim of admissibility. First, the case has not been tried by another court pursuant to Article 17(1)(c), read together with Article 20, subsection 3 of the Rome Statute. In the Gaddafi admissibility challenge, two requirements were stated that are required to reach the meaning of tried. First, there needs to be a final judgment, and second, a verdict on the merits. In the case of Lord Blaze, the decision given by the national judge was not on the merits of the case, but on whether the conditions set by law number 14 have been met. There was no assessment by the court of Lord Blaze's criminal actions, and therefore there was no decision on conviction or acquittal. Finally, we submit two arguments in relation to amnesties. Amnesties may not be invoked as, one, they are for the purpose of shielding, and two, they are prohibited under customary international law. Your Honors, the ruling given by the national judge was for the purpose of shielding Lord Blaze, and he may therefore still be tried, pursuant to Article 20, paragraph 3, subsection A. Amnesties, by their very nature, are for the purpose of shielding, as was stated in many cases, such as the Barrios Altus versus Peru case in paragraph 41. And furthermore, Lord Blaze specifically sought out this amnesty to protect himself from any criminal prosecution, as can be seen in case facts, paragraph number 23. Finally, Your Honors, amnesties are prohibited under customary international law for grave crimes. There's a wealth of case law that confirmed this. For example, the Gaddafi admissibility challenge stated that there's a strong, growing universal tendency for grave and systematic human rights violations, including crimes against humanity, not to be subject to amnesties. Other courts have also confirmed this, such as the Special Court of Sierra Leone and the Inter-American Court of Human Rights. Accepting the amnesty granted to Lord Blaze would lead to the impunity of the crime against humanity of enslavement. Therefore, this amnesty may not be invoked before this court. This concludes the first two submissions of the prosecution. Thank you very much.
Thank you, counsel. We will now proceed to your co-speaker.
Mr. President, Your Honors, good morning and may it please the court. My name is Anna Wischermann, and on behalf of the prosecution, I will be addressing our third and fourth claim. I will firstly prove that the Chamber may not dismiss the case against Lord Blaze on the basis of an assessment of the interest of justice, and secondly, that there are reasonable grounds to believe that Lord Blaze is individually criminally responsible as a superior. In relation to our third claim on the interest of justice, the prosecution's argument rests on two grounds. One, that the Chamber does not have the competence to review the decision of the prosecutor under Article 53(3)(b), and two, that there's no indications that proceedings against Lord Blaze would not serve the interests of justice. In relation to the first of these two submissions, the prosecutor, of course, acknowledges the supervisory function of the pretrial chamber. However, in relation to the interest of justice, this function is clearly limited under Article 53(3)(b) to review of negative decisions of the prosecutor, meaning decisions not to proceed with an investigation or prosecution. This was confirmed by this court in the situation in the Democratic Republic of Congo on pages 4 and 5, and the situation in Kenya, paragraph 63. In the case at hand, the prosecutor has issued a positive decision to investigate and prosecute Lord Blaze. There is no negative decision for the Chamber to review, and there is accordingly no basis for the Chamber to exercise its power under Article 53(3)(b). Should the Chamber nonetheless find that it has the power to review the consideration of the prosecutor, it shall find that there are no indications that proceedings against Lord Blaze would not serve the interest of justice. Within this claim, the prosecution wants to firstly reiterate that the assessment of the interest of justice is a negative one. the prosecutor shall proceed unless there are clear indications that doing so would not serve the interest of justice. The prosecutor therefore does not have the obligation to affirmatively determine that an investigation or prosecution would serve the interest of justice. This follows both from a plain reading of the provisions in Article 53 and was also confirmed by the appeals chamber of this court in the situation in Afghanistan in paragraph 49. Your Honor, considering the stage of proceedings, it is reasonable to assume that the prosecutor has already assessed the interests of justice and came to the conclusion that there's no indications that proceedings against Lord Blaze would not serve the interests of justice. And this is based on the factors set out in Article 53, such as the gravity of the crime, the interests of the victims, and the role of Lord Blaze in the crime. Your Honor, it is clear in this case that the gravity requirement is fulfilled. We are dealing with a large-scale, systematic, and violent attack against the Earthbowers. 40 detention centers were opened throughout the Fire Republic, and at least 30,000 Earthbowers were enslaved in Centuric alone. As for the interests of the victims, there are no clear indications in the case facts about the interests of the victims. However, once again, we want to reiterate that this is a negative assessment, as there are no clear indications that the victims would oppose the prosecution of Lord Blaze. This court shall proceed with the case against Lord Blaze. Lastly, as for the role that Lord Blaze played in the crime, Your Honor, Lord Blaze failed to fulfill his duties as a superior. Within my next claim, I will further explain the role that Lord Blaze played as a superior. However, Your Honors, Lord Blaze's role was far greater than his omission to fulfill his duties under Article 28b. Lord Blaze was the one who initiated, facilitated, and oversaw the enslavement of the Earthbowers in Centuric. Based on these factors...
Counsel, may I interrupt? So you are applying the 28b test to Lord Blaze, and you will note that you have a higher prosecutorial burden when it comes to civilian superior subordinate relationships. And that in this case, it is your burden to show a willful blindness by Lord Blaze. In other words, you cannot apply the standard of, applicable to military relationships, which is knew or should have known. Here, it is imperative that you show, you must satisfy the higher standard. Can you demonstrate that for Lord Blaze, please?
Yes, Your Honor. To fulfill the mental element under Article 28b, the prosecution needs to show that Lord Blaze either knew or consciously disregarded information which clearly indicated that the crimes were being committed. And we are submitting that Lord Blaze knew about the enslavement that was taking place in Centuric. Here, there are several factors which clearly show that Lord Blaze fulfills this mental standard under Article 28b. There was an established reporting structure set up between Lord Blaze and his subordinate Ursa Azila through the Anti-Extremism Executive Order. Ursa Azila reported directly to Lord Blaze every 6 months through reports. And Your Honors, all of those reports were submitted, as can be seen in clarification to the case facts number 2. In addition to this reporting structure, communication between the two also took place via phone, as can be seen in Exhibit 1. And during this call, Lord Blaze and Ursa Azila discussed specifically the situation, transporting, and holding of detainees in Centuric. Lord Blaze was aware of the exact number of detainees and the exact number of BNS agents in Centuric. In addition to this, Lord Blaze was also actively involved in the running of these centers. When Ursa Azila requested more materials in line 14 of Exhibit 1, Lord Blaze replied to her, and I quote, "I will see what I can do." a few weeks later, this request was fulfilled by the Office of the President, as can be seen in Exhibit 2. Based on Lord Blaze's detailed knowledge of the conditions and the center and the established reporting structure, the prosecution submits that there are reasonable grounds to believe that Lord Blaze knew of the enslavement taking place in Center Rig.
If I intervene with a small question, presiding judge.
Yes, please, Judge Maged.
Tell me about Exhibit 1. This is a phone call between the President and the Minister of Interior, is that right?
Yes, that is correct.
How this evidence was collected?
Your Honor, this is an excerpt obtained by the Water Kingdom, and it is stated in clarification to the case facts number 7 that the obtaining of this excerpt did not violate any international laws.
So you did understand my question correctly, and the goal of my question. This evidence was collected by interception, is that right?
Yes.
From another country?
Yes, that is correct.
Do you think this is a legal evidence to be submitted to the International Criminal Court?
Yes, Your Honor, that is a legally collected evidence, as once again stated by clarification to the case facts number 7, which clearly states that the evidence in Exhibit 1 was not obtained by any means violating the Rome Statute or internationally recognized human rights.
The point here, the evidence was illegally collected. However, such evidence may be accepted and admitted before the International Criminal Court. But in essence, it is illegally collected.
Your Honor, it is stated in the clarifications that it does not violate any standards under the Rome Statute. Therefore, our submission would be that it was not illegally collected within the meaning of the Rome Statute and may therefore be used by this court when determining the guilt of Lord Blaze.
Thank you so much, counsel. Your time is up. And I don't know if Judge Maged is satisfied with the answer or if any of my colleagues would like to ask additional questions. Judge Maged, should we proceed? Or?
Thank you, but I just want the counsel to distinguish between how the evidence was collected and whether it is legally collected or illegally collected. And because in many circumstances, the International Criminal Court, can accept such evidence unless they violate fundamental human rights. Thank you.
Thank you. Thank you so much, Judge Maged. Any of my colleagues would have questions for the second speaker. Please, Judge Solomy Bossa.
Thank you, Mr. President. Counsel, this alleged superior and subordinate relationship between the two people you've been talking about, can you throw more light on this, please?
Yes, Your Honor. Lord Blaze is the superior of both.
My question is, should we presume it, or is it a matter of proof by evidence?
Your Honor, the superior-subordinate relationship may not be presumed, but based on the facts that are available to us, it is clear that there existed a hierarchical relationship between Lord Blaze, the Minister of Interior, Ursa Zila, and the BNS agents. Does that answer your question, or would you like me to clarify further?
Yes, please, if you can, in a minute.
And after Judge Bossa, we will also hear the question of Judge Schmitt. Please, counsel, just proceed to reply again to Judge Bossa, and then we will get the next question.
And Your Honor, this relationship between the two can be clearly seen from the fact that Lord Blaze had effective authority and control over both Ursa Zila and the BNS agents. And this is based on two things. First, his official position as the president and secondly, his power to give orders to both Ursa Zila and the BNS agents, which can be clearly seen in Exhibit 1 and in the case facts, paragraph 17.
Thank you, Counsel.
Thank you, Counsel. Judge Schmitt.
Yeah, I would like to ask you how you interpret this Exhibit 1. So this telephone conversation, we have now heard that it at least does not violate principal human rights laws. And what is the probative value of it? If you look at it, when I see here, Lord Blaze says, I just ordered the release of some of the detainees there. And then he is asked by Zila Ursa, we might need more men and supply. And he said, I will see what I can do. How do you as prosecution interpret this in a way that could lie him with regard to Article 28(2)b? Could you explain a little bit how your interpretation of this, this telephone conversation is with regard to your case? Thank you.
Yes, Your Honor. The prosecution uses Exhibit 1 together with Exhibit 2 to show that Lord Blaze had in fact knowledge of the crime taking place in Centuric. As we can see in Exhibit 1, Ursa Zila shares with Lord Blaze details about the conditions in Centuric. And we also see that Lord Blaze was actively involved as he was in charge of ordering the release of prisoners. He was in charge of moving prisoners between the centers. He was aware of the conditions in the centers, and he provided the materials that were used to exact forced labor on the detainees. And this follows from Exhibit 2 and the fact that Lord Blaze tells Ursa Zila, I will see what I can do. And then later this request is indeed followed up by the Office of the President.
Yeah. Thank you very much. Of course, one could also argue that Exhibit 2 could perhaps be interpreted also in a more neutral way, but I'm satisfied with your answer. Thank you very much.
Thank you.
Presiding Judge, if you allow one small additional question.
Yes, of course.
Thank you. Thank you. Counsel, you mentioned that Lord Blaze had effective authority and control over the activities of his subordinates, but what is your exact evidence to that?
Your Honor, two factors that can be used to prove effective authority and control are the official position of the suspect and his power to issue and give orders. And that was established by this court in the Bamberg Confirmation of Charges, paragraph 417. And Your Honor, as the President of the Fire Republic, Lord Blaze held the highest official position within the country, and this afforded him the power to issue and give orders. He issued the anti-extremism executive order, as can be seen in case facts paragraph 7, and he gave orders directly to the Minister of Interior, Ursa Zila, and to the BNS agents. Several examples where Lord Blaze made use of this power in Exhibit 1 is the movement of 10,000 prisoners, and that he was the one in charge of ordering the release of detainees. And he was the one that ordered the BNS agents to stop the conflict and start peace negotiations. And the BNS agents complied with this order, as can be seen in case facts paragraph 17. And it is therefore our submission that Lord Blaze held a position of effective authority and control over both Ursa Zila and the BNS agents.
Thank you.
Unless I may be of further assistance, this concludes the submissions of the prosecution. Thank you.
Thank you. Thank you very much, counsel. In fairness to the defense, we will have to also extend your period by, I note here, 7 minutes to equalize the terms of the presentations this morning. I understand, counsel, that you are the sole, you will make the sole presentation for the defense. So you have your entire 25 minutes. Please proceed.
Thank you, Mr. President. May it please the court, I seek to make 4 submissions to your honors today. Firstly, that the court does not have jurisdiction. Secondly, that this case is not admissible. Thirdly, that pursuing this case is not in the interest of justice. And lastly, that Lord Blaze is not criminally responsible for the alleged crime. Starting with jurisdiction. The defense accepts that the requirements for temporal jurisdiction under Article 11, as well as for jurisdiction ratione loci and ratione personae under Article 12.2 are met. The issue in the current case is with regards to subject matter jurisdiction under Article 5. An analysis of subject matter jurisdiction looks at constitutive elements as well as contextual ones. Now, Your Honors, it suffices for the defense to prove that only one of these elements is not met for there to be a lack of jurisdiction. The defense contends that the requirements for constitutive elements have not been met, in addition to the fact that two key contextual elements are also missing from the case at hand. I will make 2 points to this end. Firstly, regarding constitutive elements. The requirements for constitutive elements are defined under Article 7.2, which state that enslavement refers to the exercise of any or all powers attaching to the right of ownership, with the elements of crimes document expanding on this, stating that it could either be in the form of a commercial transaction or deprivation of liberty. Your Honors, there is no commercial transaction in this case. And in opposition to what was submitted by the prosecution, the people detained in Center Rig were not subject to deprivation of liberty above and beyond what would have been accepted at an institution of this kind. Such, there was no forced labor exacted on the individuals concerned. The centers housed educational programs for the rehabilitation and reintegration of individuals who took an active part in the hostilities in Blackmount. The program was was on a voluntary basis, and this is evidenced by the fact that their stay in the center was amended upon proof of rehabilitation. Additionally, the detainees were all released in 2019. Therefore, the detention was not limitless. Secondly, Your Honors, turning
there. Sorry to interrupt you, Counsel. Mr. President.
Judge Bossa, please.
Yes, Counsel, I'm wondering about the conditions of detention of these people. When someone is arrested, what does due process require of the person who has arrested the person? And two, when you say voluntary stay, I don't know whether I misunderstood the facts, but my take on the facts is that these people cannot escape. They are sort of guarded, and they've been given some conditions for their release. Forget about the blanket release which occurred later, but that is what I understand the position to have been before that. Can you please comment on those two aspects, please?
Your Honor, I will address your question in two parts in chronological order of how you've asked them this morning. Firstly, on the question of due process. Your Honor, the defense contends that any possible lack of due process represents, and the concerns that come with that, represents issues with the constitutional rights limitations that are associated with the state of emergency that the Fire Republic has found itself in during this conflict. Your Honor, the lack of due process does not mean the lack of consent. And it's consent that is needed to make a decision about whether or not there was forced labor, which happened. Going on to your question regarding whether the the stay at the detention centers was voluntarily done. Your Honor, there is no evidence to demonstrate that the labor was involuntary. And the pieces of evidence which are available to this court, which Your Honor pointed out, are from Ursa Zilla on one hand, the Ministry of Interior, and Heru Rock, a designated terrorist. Now, while the defense understands that it may be a very difficult task to rely on the word of the individual who is the alleged direct perpetrator of the crimes at hand, it seems equally difficult to rely solely on the words of an individual who had every reason to speak out against the state. And it is only through Heru Rock's testimony that we have the description of what the detention centers were like on the inside, allegedly. The latter is merely hearsay, Your Honors, and being so puts it well under the threshold of evidence presented in this chamber. This is in addition to the fact that there are contradictions in his statement, which I will mention further in my submissions. And the defense notes that the PTC does not have as high of an evidential burden. That is true. However, there still needs to be a minimum level of evidence to meet the PTC's trial of the fact that there is a reasonable basis to believe under Article 58(1). Your Honor, if I may proceed, does that answer your question?
Thank you, you may proceed.
Your Honors, turning to the contextual elements, which are also an issue in this case. The crime against humanity of enslavement requires that the crime was committed as part of a widespread or systematic attack against any civilian population with knowledge. There are two requirements from this list which are not met. Firstly, the fact that there's no state or organizational policy at play. And secondly, that Lord Blaze did not have knowledge of the alleged crimes and therefore cannot be described as the direct perpetrator. Now, regarding the question of policy, according to the Elements of Crimes document, there has to be an active promotion or encouragement of the attack against a civilian population. Now, when in application of this requirement, as was done in the 2014 judgment pursuant to Article 74 in the case of Katanga at paragraph 1106, it was clearly stated by the court that the course of conduct constituting the attack must be executed pursuant to or in furtherance of a policy to commit such attack. Therefore, the defense contends that this suggests that there must be a policy to commit the crime of enslavement itself, which, Your Honors, the prosecution has failed to prove. Now, referring to the bucket of factors, if they may be coined as such, from the Nataganda case, from the judgment at paragraph 674, which lists the considerations that the court took in mind when determining whether there was a policy in that case. We see that there are crucial elements missing here. Notably, the fact that there were no explicit statements made by Lord Blaze encouraging the attacks to happen at Center Rig. The second contextual element in issue, knowledge. The defense notes that this requirement of knowledge differs from the requirement for criminal responsibility, which we will come to later. This examination only pertains to knowledge of the attack by the direct perpetrators of the alleged crime.
Counsel, I wanted to, Mr. President.
Yes, please, Judge Bossa, please proceed.
Counsel, you have said that there were no statements from the president, encouraging the attacks and so on. Can conduct occur by omission? Can someone be judged, by omission, by omitting to do what they should have done? Could it be interpreted as encouragement?
Your Honor, as per the footnotes in the Elements of Crime document, there are certain instances where omission can be used to find a policy. However, this type of policy is not applicable to situations where the act was solely done by the government. Therefore, this means that this application of the idea of a policy via omission is not applicable to the case at hand, and that Lord Blaze needed to have known that the attack was going on and that he was taking part in the attack to satisfy, sorry, my apologies. I mixed up the knowledge requirements with organizational policy, but basically the policy is that there must have been active encouragement or promotion, and Lord Blaze, and there's no evidence to suggest that there was that. My apologies again, Your Honor. Proceeding to the requirement of knowledge. So I mistakenly gave your judges the definition for the requirements of knowledge, which I will now reaffirm, which is that the perpetrator, and this is pursuant to the decision pursuant to Article 61 in the Bemba case at paragraph 88, the perpetrator must have been aware that a widespread attack directed against a civilian was taking place and that their actions were part of this attack. Your Honors, Lord Blaze declared that he did not have knowledge of the atrocities committed in Center Rig. Additionally, there were no indications that the BNS reports that he received contained any information about the atrocities in Center Rig, nor can it be argued that he was given this information during the telephone exchanges, which have been encompassed in Exhibit 1. May it please the court, I now move on to the defense's second submission, that the amnesty laws as law number 14 should be recognized by the ICC in accordance with the principle of complementarity. I will make 2 points here. Firstly, there would be a clear violation of the complementarity principle if this case is found to be admissible. Lord Blaze has already been subject to legal procedures assessed by a court of law, which has given a final decision for the act which is subject of this complaint. Your Honors, the Rome Statute does not require a prosecution and/or a criminal trial in the traditional sense of the word, as long as the procedure does not undermine the court's object and purpose. Recognizing amnesty laws is not outside of this court's capabilities. Taking, for example, Article 17(1)(a), there is no reference to the kind of investigation that ought to take place. It could be understood that the investigation does not have to be of a criminal nature, as long as there are proper mechanisms in place to ensure accountability and redress.
Counsel, may I interrupt? But perhaps precisely for that reason, this court must look into the independence and fairness of these proceedings. In other words, fine, perhaps the national authorities have the authority to proceed with their local amnesties, but the court must also be satisfied that these proceedings were fair, that it gave for instance, the victims an opportunity to be heard. In this case, the BNS proceedings, the terms were written by Lord Blaze, by the government of Lord Blaze and himself. There were no proceedings equivalent to a trial on the merits that should satisfy the requirements for res judicata. Can you assist this court to satisfy itself that it should recognize these amnesties, please?
Your Honor, we argue that the amnesty does not stand by itself to amount to the threshold needed by this court, as Your Honor has correctly pointed out. However, we contend that when looking at the amnesty and the fact that this amnesty is under full judicial control, in partnership with the creation of the Truth and Reconciliation Commission, we contend that this elevates this amnesty to the level of a trial accepted in this jurisdiction. Your Honor, what happened in South Africa, talking to the point regarding your comment about the interest of the victims, what happened in South Africa upon its creation of its Truth and Reconciliation Commission is evidence that retributive justice, as that carried out at the Nuremberg trials, as an example, is not the only path to justice. In fact, in some situations, restorative justice might be more suited to the needs of the community. And we find that, Your Honor, in the fact that it was actually the AANG who requested the creation of the Truth and Reconciliation Commission. We suggest that this request enlightens the court as to what the community feels like the best recourse to justice entails. Your Honor, you are right to state that this court should look at whether things were done independently. However, we contend that this would only be the case if this court finds that there's reason to believe that the procedure undertaken was in an attempt to shield Lord Blaze from any prosecution, which is in line with one of the exceptions to Article 17(1)(c) under Article 23. However, Your Honor, there is no proof of lack of willingness on behalf of Fire Republic to either prosecute or investigate individuals. And this is evidenced by the fact that Fire Republic is open to the more traditional criminal trial for those who have committed crimes, but who have not undergone the amnesty process. Therefore, we state that the amnesty process, in addition to the presence of the Truth and Reconciliation Commission, elevates it to a trial, to the status of a trial without replacing a trial, importantly, which is acceptable under this court. Your Honor, may I assist your question in any further regards?
Please proceed with your presentation.
All right.
May I ask an additional question, Mr. President?
Yes, please, Judge.
Absolutely.
So we are talking about the case is being investigated or has been investigated. Now, I'm wondering whether the case under the amnesty law is the same as the case which is before the ICC. Can you throw some light on that?
Just a quick clarification, Your Honor. Are you referring to the merits of the case in both jurisdictions?
Well, I'm talking about Article 17 because it's talking about the case. You know, the case is being investigated. So what case are we talking?
Yes.
I'm talking about the case under Article 17. So what case are we talking about here? Because at least the case before the ICC is clear. But what is the case with regard to the amnesty law? Are they the same?
Your Honor, the defense contends that when the amnesty went under purely judicial control, the terminology that comes with assessing amnesties takes on the same form. Therefore, the case at the domestic level, which we're seeking admissibility for at this level, is that of looking at whether Lord Blaze could have been granted amnesty as a result of him fulfilling the requirements which have been laid out under law number 14. Now, the requirements are what includes also the merits of the case, which are similar to the merits here, where Lord Blaze explicitly refers to the atrocities in Center Rig, apologizing for the fact that he didn't know, and as well as mentioning the direct perpetrator of the crime, of the alleged crime. So we argue that the fact that the judiciary considered this case of granting Lord Blaze an amnesty, including the fact that the merits are the same, equate the two cases. And actually, it's equally as understandable to look at the confines of what the case was at the domestic level as it is at this level, Your Honor.
As a matter of fact, I am going to build on the previous question. When we look,
proceed, Judge Maged.
Thank you. When we look at Article 20, which is the base of your argument here, that a trial has already occurred. First paragraph of Article 20 restricts the scope of protection to persons who have been convicted or acquitted. It is clear. And you, of course, you know, when the court will decide here, it will look firstly to the statute. And the provision of the statute here is clear. To accept your bleeding the principles of the bis in idem, the person should have been tried by a court and should have been convicted or acquitted. Thank you.
Well noted, Your Honor. Under Article 21, there is the language of convicted or acquitted. However, Your Honor, we argue that this decision by the judiciary in Fire Republic has the same finality as that of being convicted or of being acquitted. In fact, Lord Blaze having been granted this amnesty is legally contiguous, one might argue, to the idea of being acquitted by the court in the Fire Republic, because of the requirements that he had to undergo and the fact that a judicial review of those requirements followed, which led to a final decision regarding the fact that he would, from that point on, be acquitted of any possible alleged crimes that could come his way.
This is your interpretation and understanding of Article 20, paragraph 2. But can you sustain your argument by any other legal basis?
Your Honor, we argue that actually the fact that the Gaddafi case leaves the door wide open for the admissibility of amnesties is jurisprudence to sustain the idea that amnesties is not outside the scope of this court's capabilities. In fact, Your Honor, the latest Gaddafi judgment explicitly reverses the trial chambers before its decision that the pretrial chambers before a decision that all amnesties cannot be accepted at the court. We contend that this jurisprudence at the highest level allows for this interpretation to occur, because that would be the only way for this interpretation, for what the court said in Gaddafi, to hold ground. If the court has no further objection, I would now like to move to the defense's penultimate submission, that going forward with this case would not serve the interest of justice. We contend, Your Honors, that there are two ways in which the interest of justice element under Article 53 can apply. Firstly, it can apply in its jurisdictional nature, that is, whereby it is assessed by the court in relation to whether or not the prosecutor can initiate an investigation. We see this type of application in the situation concerning Afghanistan. In that case, the PTC's involvement, as opposed to this one, is at a much lower stage in the judicial process, where the prosecutor was simply getting approval of the PTC in accordance with Article 15. Therefore,
excuse me. That's not quite how the rules are stated, right? As the prosecution has demonstrated, the PTC gets to enter the picture only if the OTP, the prosecutor, makes a negative finding. And that is exactly, I think, the point where you are. That is the Afghanistan, the stance in the Afghanistan case. So I think we should dispose of this issue first before we get deeper into this matter. Maybe the PTC shouldn't even get into the picture at this stage, precisely because it was for the OTP to have made that determination to start with. Can you address that, please?
Of course, Your Honor. And the defense contends that actually a closer reading of Article 53(3)(b, which the prosecution used, reads that the article only says what the PTC can do. It does not state what the PTC cannot do. The only jurisprudence on what the PTC cannot do was rightly stated by Your Honor in the situation concerning Afghanistan in the latest appeal, where the appeals chamber specifically told the PTC that it was not allowed, it overstepped by looking at the considerations of interests of justice when analyzing a situation under Article 15. However, it does not pose any limitation on the PTC's ability to review the interest of justice on substantive matters. And this is what the defense argues is the case in the present hand. It's open for interpretation, Your Honor. There is no definition anywhere in the ICC or in jurisprudence that says that the interest of justice element needs to be narrowly defined or applied. In fact, Your Honor, we suggest that it is under the PTC's obligation to exercise its right of judicial oversight to get involved at this stage regarding the interest of justice question when we're beyond the stage of initiating an investigation. If I may proceed, Your Honor, and in the interest of time, the defense will now move to its last submission, that Lord Blaze is not criminally responsible for the crimes against humanity of enslavement. Firstly, regarding the element of effective authority and control. Lord Blaze did not have the material ability to prevent or to punish criminal conduct. Your Honors, Lord Blaze was far removed from the chain of command, which, as was highlighted by the 2005 ICTY decision in Limage, means that he could not have prevented the alleged crime from happening. Lord Blaze appointed Ursa Azila as the leader of the BNS, which was the organization tasked with solely monitoring the situation in Black Mound. All responsibility shifted from Lord Blaze to Ursa Azila at that point, and at least a few degrees of separation was created between them, as was evident from the fact that their conversations were purely of an administrative nature. Additionally, when it came to sending the materials, it was the president's office, the head of his administrative team, that dealt with the request, not Lord Blaze. Therefore, any crime committed would have been outside the scope of his effective command. Additionally, Lord Blaze did not possess the information which would have made him aware of the commission of this crime. Article 28, Your Honors, clearly states that Lord Blaze must have either known or consciously disregarded information that was clearly indicated to him. Now, Your Honors, the defense wishes to stress the latter part of that requirement, the idea of needing for something to be clearly identified or identified. Based on the evidence available in this case.
Counsel, just to notify my colleagues, counsel is now on using the extension of time being given to her, taking into account the extension earlier given to the prosecution. So we are roughly in the last 5 minutes. And if you wish to ask your questions, please feel free to do so. Please proceed, counsel.
Thank you, Your Honor. Based on the evidence available in this case, Lord Blaze would not have known that enslavement would occur in the ordinary result of things, as his communications with Ursa Azila were purely of a procedural nature. Therefore, he would not have had any personal knowledge of what was happening. Thirdly, Your Honors.
Presiding Judge, if you allow me to ask short question, Counsel,
Yes, please.
don't you think that Lord Blaze, in his authority, should proceed with his responsibility, although he appointed another person to oversee the activities? Or do you think that the fact that he appointed another person prevented his responsibility? Thank you.
Your Honor, we contend that because of the severity of the situation that was going on in Black Mountain, of course Lord Blaze should have followed through with his responsibility above and beyond just appointing Ursa Azila. And we contend that he did just that by not only ordering Ursa Azila to send reports to him every 6 months, but also the fact that when he did see indications of overcrowding, he mitigated possible problems from happening in the future by moving people, which again, we contend is an administrative nature, which would have been done in any educational center if that was happening.
Do you consider it was enough from him to request reports every 6 months, or should he has to pay more attention? Would you have any case law concerning this situation?
Your Honor, we suggest that what Lord Blaze did was already above and beyond what was expected of him after giving Ursa Azila the necessary responsibility. Your Honor, we suggest that the fact that Lord Blaze was trying to reach a peaceful situation in Black Mountain was still taking part of his time. And the fact that he was engaging actively in the peace negotiation process simultaneously meant that already the fact that he had received those reports meant that he was trying to establish his responsibility as best as he could under what responsibility that was left, that was reasonably expected within his power to fulfill. And that I see I have 1 minute left, Your Honors, and I will quickly round up the criminal responsibility ground, which is that the actions taken by Azila were not a direct result of Lord Blaze's failure to exert control over any of his subordinates. And this is clear by the 2018 extremism order, which clearly states that the centers, the order does not state anything about the centers. In fact, it was purely Ursa Azila that decided to create them. And we see from the Murakumura case's application pursuant to Article 25, which we argue is legally contiguous to the case at hand, the chamber found that proven authority over direct perpetrators supports the conclusion that his order had a direct effect on the commission of the crimes. And Your Honors, in this case, because we could not prove the direct responsibility and direct authority over Ursa Azila by Lord Blaze, we cannot prove that there was a direct effect of commission. And if I may be of no further assistance to this court, the defense wishes to conclude its submissions at this point, reiterating that on the basis of the evidence provided, Your Honors, this court should not move forward with this prosecution.
Thank you very much, Counsel. We will now proceed to the rebuttal by the prosecution.
Mr. President, Your Honors, good morning again, and may it please the court. In rebuttal, the prosecution has 3 submissions. Firstly, relating to the mental element within the contextual elements. As stated by the defense, Lord Blaze would need to know that the conduct is part of a widespread or systematic attack against the civilian population. However, when making this claim, the defense has talked extensively about Lord Blaze's knowledge about the enslavement. That is not the requirement for the mens rea element for the contextual elements. And the prosecution submits here that Lord Blaze had the knowledge of the contextual element. Your Honors, it was Lord Blaze's government that was responsible for all those conducts constituting the widespread and systematic attack. Lord Blaze was clearly aware of his government's policy targeting the Earthbauer civilian population since 2015. It was Lord Blaze himself who issued the anti-extremism executive order that led to the establishment of 40 detention centers. And Lord Blaze was clearly aware that those detention centers were established, and there were 40 detention centers in the Fire Republic, which would be enough to establish that it is a widespread attack. And Lord Blaze was aware of those detention centers. Your Honors, Lord Ursa Azila reported to Lord Blaze about the establishment of 40 detention centers. And as it was Lord Blaze's government that was responsible for all the conducts constituting the attack, we submit that Lord Blaze did indeed have knowledge that the conduct was part of a widespread and systematic attack. Moving on to my second point, relating to the admissibility. But first, a clarification, Your Honors, it was extensively talked about whether the case has been investigated and that there is willingness to investigate. However, this is irrelevant for our purposes here, as we are not looking at Article 17.1a, but Article 17.1c. What is important under Article 17.1c is whether Lord Blaze has been tried by another court for his conduct. And in this case, Your Honors, Lord Blaze has not been tried within the meaning of Article 20, subsection 3. It was clearly established by this court in the Gaddafi decision in paragraphs 36 and 38, that what is needed to fulfill this requirement is that the case be final and that it be a decision on the merits, on conviction or acquittal. And in this case, Your Honors, the granting of amnesty to Lord Blaze does not amount to a decision on conviction or acquittal. The substantive issues of Lord Blaze's criminal conduct were not assessed at all. The judge merely assessed whether Lord Blaze fulfills the requirements under the amnesty law, meaning whether he apologized for his conduct. However, the judge did not make an assessment of the conduct, of the substantive issues of the conduct, and therefore the amnesty proceedings granting Lord Blaze the amnesty cannot amount to a trial within the meaning of Article 20, subsection 3 of the Rome Statute. Moving on to my final submission and rebuttal, the defense has stated that Lord Blaze is too far removed to have effective authority and control over Ursa Azila and the BNS agents. Your Honors, a similar argument was attempted by the defense in the Orich case, which stated that Orich was too remote to have effective authority and control. However, the appeals chamber explicitly rejected this submission by the defense in paragraph 20 of its judgment. It stated it is immaterial whether the effective authority and control descends from the superior to the physical perpetrators through intermediary subordinates. I see that my time is up. May I briefly conclude?
Yes, please.
Thank you, Mr. President. And it is therefore our submission that the contextual elements are fulfilled, that the case is inadmissible, and that Lord Blaze is criminally responsible under Article 28b. Unless I may be of further assistance, this concludes the rebuttal of the prosecution. Thank you.
Thank you very much, counsel. Will the defense counsel exercise the option to do a rebuttal? Yes.
Yes,
please proceed.
Your Honor, defense counsel would like to make 3 points in rebuttal based on the prosecution's rebuttals just now. Firstly, on the requirement of knowledge when it comes to the contextual elements. The defense would first like to reiterate the fact that the defense only has to prove that one of the elements regarding constitutive elements and contextual elements need to be not proven for there to be a lack of jurisdiction in this case. Nevertheless, the defense contends that The point regarding the fact that Lord Blaze needed to have knowledge of the conflict or of the centers is not in question here. Lord Blaze was the president of a country which was in conflict for a number of years. Of course, he had knowledge of there being a conflict in his country, but there's no indication to show that he had knowledge about the crimes against humanity of enslavement, and we contend that that is what is needed. Additionally, it had to have been shown that he had knowledge and he was taking an active part in the attack, and this was also not proven. Your Honors, it's a big leap to say that, to take from the fact that Lord Blaze had knowledge of the conflict in the region, but then to say that enslavement was occurring and that he had knowledge of the enslavement occurring. Your Honor, we stress that the fact that Lord Blaze declared that he did not have this knowledge, in addition to the evidence that the defense presented in their submissions, holds ground that the knowledge requirement under the contextual elements has not been met. Now, moving to the second point regarding admissibility. The prosecution stressed once again that it is the Gaddafi requirements that are needed here. The fact that there needs to be a final verdict and the fact that it needs to be for the same conduct. The defense has already addressed these in their submissions, but will reiterate their point. Firstly, in direct relation to the requirement of there being a final verdict, the clarification documents of this case facts clearly states that this decision is final. Secondly, in regards to the requirement regarding the same conduct being there, it is clear that Lord Blaze's apology referred directly to the centers that we are talking about in this case, his involvement in the centers, as well as the enslavement that occurred in the centers. We see from an analysis which the judge made at the domestic level, that pursuing the apology given by Lord Blaze regarding these things, it was found by another court that Lord Blaze did not, that Lord Blaze's amnesty is not undermined, therefore, in this case. Now, moving to the last point, Your Honors, regarding the fact that Lord Blaze was too far removed from Ursa Azila. The defense contends that it only needs 1 degree of separation for there to not be a direct overview. And the defense contends that there is large amounts of evidence available to suggest that Lord Blaze was very rarely in contact with Ursa Azila. In fact, it is his office that dealt with the sending of the materials as a procedural matter. There's only evidence that he spoke on the phone once where no incriminating evidence was found. It was a normal phone call regarding what one could assume was an educational center. And in addition to this, the BNS reports, there's no evidence to indicate that he read them. And even if he did read them, there's no evidence to indicate that Ursa Azila had explicitly written out that that the crime against humanity of enslavement was happening, or anything to suggest that that could be possibly inferred from that. So the defense holds the interpretation of the application of the 2005 decision, ICTY decision in Limage, which states that the perpetrator did not have a direct did not have effective control and authority over the situation at hand due to the fact that he was far removed from the chain of command. And with that, Your Honors, the defense rests its case.
Thank you. Thank you very much, counsel. The court will now take a break. Bench clerk.
I will now send the judges into the deliberation room and the team members into separate breakout sessions.
Thank you very much. So to the bench clerk, are we back?
Yes, we are.
Thank you so much to the bench clerk. The court has proceeded with its deliberations, but before we read out our decision, I would like to give an opportunity for my colleagues, an opportunity I also would like to take for myself later, to give their feedback to the participating teams. And I will begin, as I did in alphabetical order. I ask Judge Solomy Bossa of the Appeals Chamber of the ICC to give her comments.
Thank you, Mr. President. Thank you, teams. I must say that I've been impressed by your advocacy skills for both teams. You've exhibited a firm understanding of the law, and you have been eloquent speakers. The other thing I liked about both teams is that you were keen to ensure that when judges asked you questions, you offered answers and cross-checked to make sure that the judges understood your answers and were satisfied with them. I think that is a good trend. So I congratulate you, and I'm very proud that both teams are composed of ladies. I think that is a road that we need to celebrate. Thank you.
Thank you so much, Judge Bossa. Oh, sorry about that. Thank you so much, Judge Bossa. I will now ask Judge Ivana Hrdlickova to speak.
Thank you very much, Presiding Judge. I would like to share comments of my colleague, Judge Bossa. I've been very, very impressed by both teams, your knowledge, but also enthusiasm and the ability to interact with the judges and to answer questions, and your presentation skills. You are absolutely fantastic, and I congratulate you. It's wonderful to see you here, and I wish you all the best. Continue with this enthusiasm. Thank you.
Thank you very much, Ivana. I will now proceed to Judge Adel Maged.
I'm sorry, you're still muted.
I think I am right now. Yeah, perfect. As I was saying, it was a great pleasure working with the bench, of course, every member of the bench, and attending this final round and seeing both teams have done extremely well. As a matter of fact, the arguments were clear enough, and they well presented their cases. But as I have mentioned briefly, at this final stage, we have to add something new to the table. And this is why, as you have noticed, I and my colleagues started to ask specific questions, like the question I asked about evidence. This was unexpected, I believe, for the prosecution. And I was expecting that the prosecution will answer me by referring to the ICC statute article 69, for example, which speaks about the evidence, the admissibility of the evidence. So this is what we have done. Was our strategy is this final round to ask new questions. And for these new questions, we were expecting innovative argument as well. Something I was expecting, and maybe the defense counsel has done really well in this, is the interaction. I've been following pre-trial chamber rounds, and there were always this remark about the interaction and the virtual contact. It's very important. Both team has done very well today, much better, and especially the defense counsel. She has managed to interact with me, as a matter of fact, with a very convincing argument. So I wish to both teams all the best. You have done very well. Thank you.
Thank you very much, Judge Maged and Judge Bertram Schmitt.
Yeah, I also would like to convey that I was deeply impressed by both the presentation of both teams, especially by their flexibility when answering the questions of the judges. It's of course easy in such a situation where you have what you want to say, your speech, your submission in mind, and the structure to be taken off guard and to lose control, so to speak, of what you want to say. You did not, which is a very important skill you have to have as a counsel. Also, I liked, especially with every speaker, the emphasis they put on how they spoke. So what I mean by that is it's very important to keep every listener alert by not having the same tone when speaking. That might sound a little bit basic, but it's very important. So, but all in all, this was a great final, and I thank both teams and every speaker, and you all did a very, very good job.
Thank you very much, Judge Schmitt. And on my part, I just want to tell the council that one disadvantage you have is that whenever you invoke the Onguwen case and the Bemba case, both Judge Schmitt and I were in those cases. And so your disadvantage was you were invoking cases we knew very well. And but I admire you in having spotted the relevance of those cases to your arguments. Just like my colleagues, I thank you for your excellent argumentation. It is always very impressive that students at your stage of your studies can be so familiar with the case law of ICL, and also, of course, of the Rome Statute. I close my congratulations on that point. May I ask then, Salim, what do we do next here?
After the deliberation, after the feedbacks that their teams received, I congratulate them as well on my turn, and the presiding judge may close the hearing.
Thank you so much, Salim. In behalf of my colleagues on the bench for the final round of the 2021 Nuremberg Moot Court competition, it is my honor to read to you the decision arrived at by the judges after deliberations in the final round of the Moot Court competition. It is my honor to announce that the winning team is the team for the defense, and I congratulate the winner, the defense team, and likewise congratulate the prosecution for having gone to this final round of the competition. Congratulations to all. On this point, I close this session. Thank you.
Thank you, and congratulations to the winning team.
Thank you, and it was an absolute pleasure to appear before this bench, notably. Such an honor as a student, because I learned from every single one of you. And of course, congratulations to the prosecution.
Thank you so much. I think